received the unredacted information that had been previously redacted as work product. It is what I suspect it to be, which is a prior report from our expert. So, I find it very concerning. This is my third motion in front of this court regarding redactions and withholding of information on an improper basis. I can't think of any rubric under the work product rules or law that would entitle the Attorney Generals to redact this prior report of our expert as work product. It doesn't contain mental impressions, thoughts, or opinions of the Attorney General. And work product, especially in a criminal case, is very narrowly tailored. I mean, that's what the case law says. So, this causes me concern about what is not being disclosed to us or what's being withheld. So, I appreciate that it's been given to us now. I'm wondering what else is out there with regard to our experts, what other materials they intend on using as impeachment or otherwise. We're entitled to that information plainly under the discovery rules, and so I would ask the court to order them to turn over any additional information that they intend on using. And I'm also going to ask the court to sanction the Attorney General's office for continuing to improperly withhold information from the defense.
Sanction in what way?
Say it again?
Sanction in what way?
The court has great discretion in determining what's an appropriate sanction. So,
what do you think?
I've had to bring 3 previous motions. That takes time and effort and money. And so, I don't know if I guess that's what I would be requesting is monetary sanctions, and I can submit a fee petition and affidavit as to the work that I've done to try and to get discovery that we're plainly entitled to.
Okay. Ms. Eakes.
Yes, Your Honor. First of all, if counsel had asked us, certainly we would have gone and looked at it. As far as I can tell, it was withheld for work product, and I don't frankly know exactly who made that decision within the Attorney General's office, but because it was attached to emails that were sent to counsel from other individuals as we were developing work product with respect to who these experts were. And apparently that's the reason why it was blacked out. Once I looked at it, it's obviously just a report of an expert, one of their experts, which they can get as well, and so we turned it over. In terms of other experts, as far as the state is aware, we've given everything that we have. Certainly as we prepare, if there are any additional materials that come to my attention that we haven't provided related to their experts or other reports that we intend to use, we will disclose those to the defense. So I think, from my perspective, that's my understanding of kind of what happened and why we ultimately turned it over. There's no concerted effort to withhold anything. We understand our discovery obligation. We believed that we had turned everything over, but as I said, I think it was attached to an email that was sent to, I think, me as part of gathering information on experts. So, and that's why it was blacked out.
Okay, and it was blacked out, and the words "work product" was imposed on the document, so I take it that was the reason. It was believed to be work product. You agree now that it was not work product?
I don't believe it is work product, correct, Your Honor.
Okay. Should I impose a sanction? And if so, how much?
Your Honor, I would suggest that a sanction isn't appropriate. Again, this is inadvertent. There's a lot of discovery in the case. Obviously, the parties have been doing their best to gather information that they can, with respect to each other's witnesses and experts. And, if anything, the AG has tried to be over-inclusive, including going back, as the court knows, and providing emails and drafts and other things that were not initially provided. And so, I think that it's There's no bad faith on behalf of the Attorney General's office. There's no intent to withhold. And as I said, had counsel asked us about it and we had looked at it and seen it, there's just a lot of materials. We would have provided it, and it was, an error in terms of the way that it was produced. It's not anything, frankly, the report isn't anything that the state intends to use in any event. It's an unrelated expert report in another case.
Well, they'll sometimes get used.
Well, I can tell the court, having looked at it last night, it's not something that the state was intending to use in cross-examination. Like I said, it's a report in an unrelated case.
Well, I'll take that under advisement. As for, that is the sanctions under advisement. As for sanctions for other failures to produce, there may have been issues with respect to discovery, and I know we've had lots of talk back and forth over 2 years about this in various ways. I don't know specifically what you've got in mind, Mr. Conrad, as to these other couple of motions that you've made, and whether or not those were legitimately claimed as work product or otherwise retained and not disclosed. But so I don't have a factual basis. If you want to make a motion specifically as to that, I'll certainly consider it. Okay. All right. So then, Ms. Bremner, you said you had something else?
Right, Your Honor. First is on order of witnesses. We'd like to know if we need to have witnesses ready by tomorrow. With counsel this morning, we just wanted to check in again on when we should consider lining people up.
Your Honor, it was my understanding from Mr. Pertzer, and I'll let him speak for himself, with respect to the defense was intending to start on Monday. But I can address, in terms of our witnesses, we did make a decision not to call Ms. Mays based on the court's comments yesterday. So once we finish with Mr. Ryan, we will be calling the DNA expert, and then the state's witnesses will be concluded, we believe.
So you'll rest your case?
Yes, although I would ask that once we complete the testimony that we be given a recess and an opportunity to consult with the office as well as with the victim's family before we officially rest.
How much time?
A short time, like 15 minutes, maybe 30 at the most. So, and then I don't know what the court's plan is. If obviously the defense indicated yesterday that they intend to make a halftime motion, so I don't know what the court has planned for that, and that's why I asked Mr. Pertzer this morning about whether or not the defense was going to be calling witnesses tomorrow or not. And of course, we still have opening for Defendant Collins. We have not yet seen a PowerPoint with respect to that, but we suspect there may be some issues related to that as well. So.
And Mr. Pertzer, you're standing, so I take it you want to say something.
Just a few things, Judge. I mean, with the court's discretion, we'd like to start on Monday. We're still in the process of finalizing witnesses for the three defendants, and so we could have Wednesday off to finalize that. We do have a halftime motion we're going to be bringing as well, and I anticipate both Officers Collins and Rankin will be doing it as well. We could address that on Wednesday.
I think you need to have a witness ready.
Respectfully, we had a meet and confer on Sunday.
Yeah.
The state said, next week we will rest. Maybe the end of this week we will rest. And, it's not like this is our only case. I was told yesterday I could do a PowerPoint, and the state's now saying, well, we haven't seen a copy of it. I mean, come on, we need to have some time to prepare, and we were told third week in November 2 weeks ago, or a week ago by the state that they'd be done. Now they're saying, then Sunday they say it's end of this week or Monday. Now it's tomorrow, now it's today. I mean, we have to be able to plan. So I would join Mr. Pertzer in allowing a little leniency in the timing so that the defense can have its case ready to rock and roll.
Well, I mean, one should have had your opening prepared 6, 7 weeks ago.
Well, it's ready, Your Honor, but the PowerPoint, I'd still like to have a chance to finalize it and then give it to the state for review. And again, I didn't expect that last night would be the night that I had to do that, because the state has told us it would be next Monday they'd be done, or this week at the latest, meaning we start openings on Monday.
Mr. Conrad, you've risen. I take it you've got a comment too?
Yes, I'm looking up the email from Ms. Eads, which says that the state expects to present witnesses next week and hopefully rest no later than 11/13. And then we met and conferred on Sunday, and so it seems to be a bit of a moving target, which I understand, but we've been planning, that's what's been represented to us, so we've been working on getting witnesses lined up for Monday, and I think we can be efficient with our case. We talked about being efficient yesterday, and I think that we're going to do that.
And Your Honor, I would just say, I mean, obviously, we're giving our best estimates. When I said on Sunday, we didn't know that the defense was going to be objecting to Ms. Mays. Then the court indicated its comments yesterday that it was not particularly inclined, given the defense objection, for us to call Ms. Mays. Obviously, that's changed things. The one thing I guess I didn't say was that the state is still and expects that we will, depending on the course of cross, that we will renew our request to be able to call Mr. Hicks and Mr. Lee as witnesses, one or the other or both. That's obviously something I'm not building in, because I'm assuming from what the court has said before that you're still not going to allow us to call those witnesses. But I would just flag that as kind of when I'm trying to give my best estimate, and I think I said this on Sunday, that it also depended on if the court adhered to its prior rulings with respect to timing. So just so the court's clear, I mean, we're not trying to spring any timing issues on anybody. We defer to the court with respect to whether you want to let the defense start on Monday or not. We're just giving our best estimates, given a moving target of what precisely we're permitted to put in. So,
Ricky's fingers are twitching. I think he wants to say something.
If I can pipe in a little bit, Your Honor.
I feel like I'm an auctioneer, and there's these little gestures are getting made. I'm trying to figure out who's making a bid. Go ahead.
I don't know, and I don't want to put any pressure on Mr. Arthur, but you may as a compromise, we could do the halftime motions in the morning, and if has his PowerPoint ready, he can do his opening, then with the court rules in the afternoon, and then witnesses Monday morning.
That'd be fine, Your Honor. I mean, I'm ready to go, like you say. I just did want to give the state at least a night to review my stuff, and, you know, I didn't do it last night because I took my kids to swimming class instead of getting that organized, so, because I expect to have a few days.
Well, I don't know that the motion is going to take half a day. But, well, I'll compromise to this extent. You can call your witness, the first witness on Monday, but if we've got time, I expect the opening statement. And if you haven't got the PowerPoint ready to show it to the state, then I'll do what I did with everybody else. You don't get to use it. So
Will the opening be in the morning or the afternoon, Your Honor?
it'll be whenever the time slot
Okay.
lands.
Whenever we're done.
Yeah. Okay, Mrs. Winnie, have you checked on the jury lately?
I have one more matter, Your Honor.
Oh, I'm sorry, go ahead.
Speaking of efficiency, I did lodge the objections yesterday on this witness, but we'd like to have Mr. Conrad do the cross. I think it'll be a lot more efficient. We have a jury that's anxious to get through this and get it done. And I raised this with the council this morning. They said they defer to the court kindly. And finally, we went through everything last night. I have terrible insomnia. I've been up at 3 the last 2 mornings. So he's 27 years younger than I am, Your Honor. So maybe he'd be more efficient in all respects. And it's discretionary to the court, of course.
If you could only have made me feel worse if you had pointed out that you were younger than I am. Well, the state have a comment.
Your Honor, as I indicated to Ms. Bremner, we'll defer to the court on it. It's my understanding that she doesn't feel well, and that's why she's asking to have Mr. Conrad do the cross. So,
Co-defense counsel have a comment.
No objection, Your Honor? No problem.
Then that's fine.
Thank you, Your Honor. Thank you, counsel.
All right. How are we doing with the jury? They're all here?
one other issue, Your Honor. It's my understanding, perhaps, that there's an issue about exhibits, Ms. Winnie?
I have to check with Judge Cheshkov on his records. We do know that Exhibit 545 is admitted on 1019, so I'll make the change on my exhibit list. But the other ones, I have questions on.
Which one?
Okay.
Is there more than one?
Perhaps we can do it later. It's going to take some time, Your Honor.
Okay.
Okay. I just wanted to make sure we just teed it up to make sure we get it resolved before the state rests.
Right, you're not going to rest today. We're trying to do it.
All depends.
Yeah. I don't know, Judge. If you want to take the time, we can do it now.
No, that's fine. We can do it later. All right. So we're ready for the jury? Let's have the jury then. Okay, welcome back, everyone. Please be seated. Okay, Mr. Trickey, resume when you're ready.
Good morning, Mr. Ryan.
Good morning, sir.
So yesterday, amongst other things, you had indicated, I believe on direct, that officers, of course, in their training, they have to follow the Constitution best they can.
Of course.
Right? And then they follow the laws of the state,
Absolutely.
and then they follow the guidelines or policies of the particular agency they work for.
Of course.
And I don't know if you consider that a hierarchy, but I think we we can agree at least the Constitution controls everything from federal to state law.
Constitution controls every agency in the country.
Right. And then ultimately, it's not for you to decide what the Constitution requires. It's ultimately the courts that make that decision. Do you agree with that?
I would agree, but certainly from a standpoint of law enforcement training, officers have to be trained on what they can do and what they can't do based on the Constitution.
And you do the best you can in your training, taking that into consideration.
I don't follow the question, sorry.
Well, you do your training in that context, right?
Well, certainly all training has to be in that context.
Right.
Otherwise, an officer wouldn't know when they could arrest somebody, wouldn't know when they could stop somebody.
Right. But I mean, you base it on your interpretations after you went to law school, for instance. You read the Graham case, and you read it, and then you interpret it, and then you train on it.
Well, I think some of it just sets principles that are trained throughout the United States.
Right, and that's, I'm not saying it doesn't, but I'm saying you do the best you can. You have to have an interpretation. That's what case law is all about.
Yeah, it's not really an interpretation when there's rules.
Okay. And so, once that goes on, then you said yesterday you looked at state law, and you didn't cite to the actual statute, but you mentioned a particular statute.
Yeah, Washington has a particular statute on use of force.
And it also has a statute that existed at the time of this arrest on the use of force in the context of an arrest, correct?
Yes, I believe that may be actually what I was referring to.
And the statute is RCW 10.31.050. Remember that statute?
I don't have the numbers committed to memory, but certainly if you want to show it to me, I'll be happy to look and make sure it's the same one.
Well, let me ask you this. Do you recall reading a statute that says if after notice of the intention to arrest the defendant, he either flee or forcibly resist, the officer may use all necessary means to effect the arrest? Do you recall reading that statute?
Yes.
And so that's a pretty broad-based statute, right?
Yes.
And what all necessary means, based on Graham v. Connor, might depend on the particular situation at hand.
Well, it would still, all necessary means would still have to meet the constitutional standard.
Right.
And the other state laws that talk about use of force.
Okay. That may, but that one, you don't disagree that it existed here in 2020.
I don't disagree that it existed, and I don't disagree with what it says.
And then the other thing is, you mentioned these are Tacoma police officers. They would have to follow the Tacoma Police Policy and Procedures Manual, correct?
Correct.
And you looked at that manual as part of your analysis in this case, correct?
I did.
Okay. And I would like to have shown to you Exhibit 301, not for publication at the moment. I think it'll pop up on your screen. Is that on your screen?
Yes.
Is that the part of the manual you looked at as part of your analysis in this case?
Absolutely.
And this is just one part of an entire manual, correct?
Correct.
Specifically on the use of force.
Correct. This is a 13-page document on use of force.
Okay. Your Honor, I move for illustrative purposes the admission of Exhibit 301.
Okay.
3-1 is admitted for illustrative purposes only.
And we can publish that to the jury and move on to page 2 of that exhibit. Now, part of this, again, talks about the use of force in different contexts, right?
Yes, sir.
And I think you indicated this is a combination of the Graham factors and a continuum. Do I understand that correctly?
Correct. That first page has a continuum on it.
Okay. Now, we have the second page there of this particular exhibit in front of the jury. It does leave open officers, if they're in a particular situation, going outside their training, does it not?
It does. It has a provision. It's a catch-all provision. I'm not seeing it as I look at it, but I do recall it.
Mm-hmm. I think if you look in
I think it's the third paragraph.
Well, go to the first paragraph first. It says, based on the training and the reasonable risk assessment of the circumstances, officers may respond to subject actions in order to gain compliance in control situations. Right?
Absolutely.
That's the beginning of it.
Yes.
And then later on, I think maybe in the context of the Graham factors in the provisions of the paragraphs we read yesterday, there's an acknowledgement sometimes when you're in an unpredictable situation, you got to go outside your training.
Well, I think you go outside your tools and tactics, and I think that's what it says, and the training.
And you're reading specifically in the third paragraph, as you indicated.
Yeah, I think there's a sentence there that says officers may use tools and tactics outside the parameters of department training, but they still have to meet the standard of reasonableness
Right,
as you continue it.
That's true in everything. It's got to be reasonable.
Correct. It's got to be reasonable and necessary.
With an understanding that the situations, I mean, you, for instance, yesterday you had these screenshots of the Vivint video and the McDowell video.
Correct.
And that screenshot is a moment in time.
Correct. And that's how we judge use of force, by the moment in time that the officer used it.
Right. And the officer doesn't have that advantage at the time he's using the force. Fair to say?
Well, the officer has to be trained to make those decisions.
Right. And this acknowledges, even under the best of circumstances, sometimes they're going to have to basically add lib out there, so long as it's reasonable.
Their action still has to be reasonable. I think that's why I said yesterday, for example, the chokehold. If you were in a deadly force situation, then the chokehold could be used.
Right. And we'll get to that. But the fact of the matter is, the point of it is, it allows for a person, if they're in a situation, a dangerous situation, an unpredictable situation, to use means that he may not ordinarily use.
That's correct. That's what the policy says. They still have to be reasonable and necessary.
For instance, you had the example yesterday with the state. You talked about the thing in relation to using a taser. We talked about maybe reasonable in some situations, not reasonable in other situations, right?
Of course.
And one of the things you said you consider is if there's multiple officers as opposed to a single officer, correct?
Correct.
Of course, that assumes there's one suspect, number one, correct?
Well, yeah, I used some examples on threat assessment. I said officer, offender, size, and ability, and then the number of persons on each side of the equation.
Right.
So if you had a number of individuals on one side of the equation that would be adverse to the officers, then that would make the risk threat assessment go higher. If the alternative was to take place, if you had several officers and one person, then the threat assessment goes lower.
Potentially. If you had two officers and a really strong individual, it still may be a big threat to those officers, correct?
Could be a threat. Obviously, officers are trained. Officers have tools to deal with threats. So, again, all other things being equal, you're right. I mean, you could have somebody who was super strong. I've dealt with that myself before.
Yeah. You might have two or three officers. If the guy's really strong and he's able to take on two or three officers, I don't know if it's T.J. Watt, you know who he is? Or
Yes, sir.
Someone like that. And there was two of me, and I'm an officer. I probably don't stand a chance against T.J. Watt. Would you agree with that? Don't agree too readily.
As far as ground fighting goes.
Mm-hmm. So, and when you say the officers are trained, which is a good point, the officers come into a situation, they're trained. They, in essence, under an arrest situation, for instance, if a person calls, doesn't matter, a woman is being assaulted by a person, and she's not, let's assume she's not trained, she calls the police, the officers come in and they assume her position. Is that a fair characterization in some sense?
I clear that up. I'm not sure what you mean by they assume her position.
The victim out of the way to protect her.
Oh, of course.
And that's how so they put themselves at risk.
Well, they put themselves in between, and they're potentially at risk, of course.
Right. And then part of their duty is to protect the public.
Of course.
From the scene. Protect themselves.
Of course.
And then ultimately, the third part of it is, if they can, to make sure the suspect does not get harmed.
Well, of course, that's one of the priorities.
And that'd be the last priority, actually, would it not?
Under some principles, yes, the HIPS principle.
Okay. And here, as you indicated yesterday, there's three types of, I'll just call them stops. First one's not really a stop, it's community caretaking.
Well, no, that's not what I meant. The first one's consensual. So a consensual contact, or what is sometimes referred to as a social contact, where the officer has no enforcement authority but can stop and talk to people.
Right. And in this case, in the first part of this, at least the interaction that's described, quite frankly, by everybody, to the extent they saw what happened, that was a consensual contact. Do you agree with that?
If, in fact,
I'm talking about the first moment.
yeah, if in fact the witnesses, saw Mr. Ellis walking along the sidewalk and was simply called over to the car from the sidewalk to talk to them, then yeah, that's a consensual contact. Depending on how they ask, right? If they command him to come over, then that changes it. But if that's what happened, yes, and if the officers say, hey, what's going on, and the person walks over to the car, that's also a consensual contact.
And like you read, as you indicated, the interviews done by Collins and Burbank, and Rankin for that matter, right?
Yes, sir.
And part of the interviews that you read, and I think it was Collins' statement, he says they saw him in the middle of the street basically by a car, called him over. Mr. Ellis expressed some concerns about his legal situation. They said, go ahead and sit over at the curb, right?
That's what Collins reports in his statement, yes.
And nothing wrong with that.
No, that'd be a consensual contact.
And then later on, of course, there's a difference of statements or observations as to what happened later on.
Well, no, I think the difference comes before that, because the difference is the witnesses do not see Mr. Ellis at a car in the middle of the intersection.
Okay, the witnesses.
Correct.
Who are you referring to?
So it would be the Sarah McDowell. It would be her ex-boyfriend. I'm sorry, his name's escaping me for a moment. Lowry. And it would be Seth Cowder. Is that how you say it?
Cowden?
Cowden, who's driving up.
Well, Seth Cowden actually did say he saw him in the middle. Did he not?
No, I think what he says is he sees him in the street, but near the front of the car.
Okay. Front of the car.
I believe so.
And Ms. White indicates that she saw him in front of the car, Mr. Ellis.
Oh yeah, I think they all see him in front of the car at some point.
Right. That's not on the sidewalk.
Well, no, initially though, he's on the sidewalk.
Well, not according to Ms. White and Melanie White, excuse me.
When she comes into the situation later, yeah.
You don't know exactly when she came into the situation.
Just from her statement, that's all.
And her statement she indicated was that she saw what was happening. It was several seconds later, I think 30 or no less than 30, where she hears, she didn't know Ms. McDowell, but she heard a female voice, which we believe to be Ms. McDowell, correct?
I think she said she hears something outside, and then it's as many as 30 seconds before she goes to the window, I think.
And how much time did she observe before she before she went to the strike that? How much time was she listening before she went to the window? Do you recall that?
I don't. I think she said 30 seconds. There's a 30-second window.
All right. Now you talked about the difference, and then well, strike that. If I understood yesterday, you indicated that the officers, and specifically Officer Burbank, did not have the authority to use his taser?
Correct.
Okay. And that is because of what?
Because based on the reports of the witnesses, there was no active resistance.
Okay. And so McDowell, you said specifically yesterday.
McDowell, Lowry, and I think even Cowden, I don't know that he describes any, other than trying to get away, move away from the officers.
And trying to get away is active resistance, is it not?
It can be, but it's certainly, remember, there's degrees of active resistance.
Well,
So from the standpoint of following the Constitution, as you brought up.
Your Honor, I would move to strike that.
agree, it's no longer responsive.
So, if you, and we still have, if we go to page 5 of this exhibit, and actually we have at the very bottom, subsection D, it talks about active resistance compliance techniques. You see that?
Yes.
And we'll go to page 6. You see under the enforcement electives,
Yes.
and that, under that particular paragraph, it indicates what an officer can use in the context of active resistance, correct?
Absolutely.
And one of the things that's in there is electronic control tool.
And it would still have to be reasonable under the circumstances.
That'll be up for not your decision, but that's a taser we're talking about, right?
Absolutely.
And so under the policy, assuming they're facing active resistance, certainly the Tacoma PD policy allows them to use the taser.
According to what it says there, but it still would have to be in conformity with the entire policy, which requires it to be reasonable under the circumstances.
We get that, Mr. Ryan. Okay, that's fine. That's not your determination, right?
No, I think it is. I think there is a determination. Again, and I'm not trying to argue with you, but you started out with saying that the officers have to be consistent with the Constitution. And in order to be consistent with the Constitution, you can't use it on every act of resistance.
Yeah, and I won't suggest that at all. And it's
Well, you are.
It's based on reasonableness.
But you
Right?
said
It's
you
based
said that.
on the circumstances that they're facing at the time, correct?
But you said based on the
Yes or no?
policy.
Yes or no? It's a yes or no question.
I agree they shouldn't talk over each other. There is a question posed. Answer that question if you would.
Say it again, please.
The situation is whether they can use a taser or not under an active resistance situation is based on what they perceive at that time, at the moment, correct?
Absolutely.
And
What they
then-
reasonably
then
perceive.
just ask for a yes or no response. So,
Well,
absolutely fine.
I don't know what reasonably perceives means. I think you said before, if somebody perceived a gun, that would be there could be a certain responses to that. And then it turned out later the gun was not loaded. Then in hindsight, that would not necessarily have been reasonable, whatever the force was used. So I mean, I agree with you. If you are looking at a gun and you say the guy had a nuclear bomb, then maybe that's not a reasonable perception. But in the absence of some sort of gross difference in what is being reported, and it seems to me what they're perceived is what they perceive. Wouldn't you agree?
No, because it's an objective analysis, so it has to be reasonably perceived. And that's the standard.
Well,
Well,
reasonably perceived. So if it turns out it wasn't a gun at all, but it was a toaster in their hand, would that be a reasonable perception if they believed it was a gun?
No, I don't think it would be. That would be a subjective as opposed to objective.
How would you determine whether it's a subjective versus objective perception?
Because the officer would have to say that it appeared to be a gun,
Right.
and it would have to be objectively reasonable that an officer in the same position would see that as a gun.
But if it
It's
turned
not
out it
the-
wasn't a gun,
It's not the officer's subjective belief. It has to be based on what's objectively reasonable.
I'm not sure that's true. Go ahead.
so I'm going to hand you, or Mr. Ryan, what's been marked as Defendant's Exhibit 2928. If I may. And you recognize that, do you not?
Yes,
And that's the case you've been talking about over the last couple of days, Graham v. Connor, correct?
yes.
If you look at page 397, it's, I handed it to you.
2928.
Thank you. that page in front of you?
Yes.
And do you have on the second column, the last paragraph? See
Your
that?
Honor, if we can just have a minute, we haven't been provided a copy of that.
You totally have.
Well,
Hold on a second, give her a moment anyway.
Yeah, that's fine.
just want to get a copy of it since it's not in any of our binders. Thank you.
397.
Thank you.
You tell me when you're ready. Sorry, thank you.
Yes.
So, Mr. Ryan, looking at that, you have that page 397 in front of you?
I do.
And then that second column, the last paragraph, it indicates, does it not, which is what you train, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. Is that what it says?
You're on
Yes
390.
or no?
I'm looking for it. I'm sorry. Where are you showing me on 397? I mean, that is the standard.
You can.
Without looking at it, I can tell you that is the standard.
397.
Well, 397 comes over to the next page. It starts here.
Right
Oh,
there.
I'm sorry. Yes.
And so, again, you teach that,
Absolutely.
and you judge it from when you talk about reasonableness, it's not in hindsight, it's you put yourself in the shoes of the officer at the scene.
Based
Correct?
on what
Correct.
based on what that officer knew. Absolutely.
Okay, and what he's going through and what he's experiencing. Correct?
Based on what the officer's perceptions are at the scene, but not based on a subjective perception. Yes.
Well, I didn't say so. I said reasonable subjective, right? That's what it says. No one said subjective, did it not?
No, it says on the next page that you don't take subjective motivation into it.
Right. Because what that means is when you don't take subjective motivation into account, whether it's good or bad from the subjective motivation, it doesn't matter.
That's correct. If the officer's got a bad intent, doesn't matter. If he's got a good intent, it doesn't matter. The question is, would some other objectively reasonable officer, knowing what this officer knew, do the same thing?
And knowing what this officer knew is talking about knowing what he knew at the time of the event.
Absolutely.
And so, if an officer knew that a person assaulted his vehicle and threatened him, and then threw them on the ground, one of them, and was intending to inflict pain in them, they would be able to use some type of force. We would agree with that, correct?
Absolutely. I think I said that yesterday.
And that would include application of a taser.
If the person was fighting, punching, kicking, absolutely.
And as Ms. White indicated, certainly he was pulling away, grunted like he was trying to escape the grasp of an officer. Remember that?
Pulling away, yes.
She said more than pulling away, she's straining to get away, is what she said, did she not?
Well, again, pulling away, absolutely.
Okay. Now, in the context of this, you talked about objective evidence yesterday, right?
Correct.
And you talked about specifically in the context of the video, correct?
Yes, I don't know that, I may have used that term because it's a term I often use in both training and in other formats.
Okay. And so when you say objective evidence, what are you referring to?
I'm referring to stuff that can't be changed by a person. And when I say that, for example, the video shows what it shows.
Okay. But a
So it's
still
objective.
frame from that video doesn't necessarily show what happened.
Doesn't necessarily show it in real time, but sometimes you need to do a frame by frame. I do it in my audits. I do it in all different contexts in order to see what's happening at a given moment.
Right. Well, I'll just give maybe perhaps a silly example. If you were filming me right now with your phone, and I jumped in the air, and then later on you take a still frame from that video that you just made of me and I'm in the air, you're not going to tell the jury I'm levitating, right?
No, of course not.
All right, that's silly.
Correct.
It's no less silly to take a frame at what? A frame is a tenth of a second?
Depending on the frames per second, a lot of the cameras are 30 frames per second.
Well, what was the frame you looked at yesterday?
I'd have to look at Mr. Frederick's stuff. I have no idea what the frame rate was.
So if you pull the frame out, that doesn't show what's actually going on.
Well, it does. It shows individual movements and whether or not somebody's punching or kicking, things of that nature, at that given moment in time.
Okay. At that very specific moment in time.
Absolutely.
And what happened to lead up to that moment's not depicted in that particular frame that you're talking about, correct?
Well, it would be in the combination of all the frames, looking at all of them.
That's the point. You got to look at all the frames to know what's going on.
Well, and you do look at all the frames.
And you got to look at it in real time.
No, I don't agree with that.
You don't. You think an officer has the ability in his perceptions at the time when he's deciding what he's got to do, that he's going to have him jump broken down frame by frame, and how you did it on the stand here?
No, I don't believe that. But if an officer says somebody's punching them, and the frame by frame shows that the person never punched them, then we can draw a conclusion from that.
Okay. Well, Officer Burbank, for instance, at the beginning of this, as far as the approach to the vehicle on the passenger side, was that Mr. Ellis punched the car.
Correct.
And do we have objective evidence to show that?
We don't. It's not in the video.
Okay, but photographs are objective evidence, correct?
A photograph can be objective evidence as well, yes.
Let's pull up exhibit number 2732. 2732. And that's been previously admitted, so it has to be published. Have you seen that photograph?
I've seen the photographs, yes.
Okay. Testimony was that showed powdered sugar, basically. You disagree with that?
I don't know what it shows. I think there may be some dispute over that, but I don't know what it shows, whether it's powdered sugar or not.
Well, are you
I can't say for sure.
Are you suggesting it's cocaine residue?
No, I don't know what it is.
Are you suggesting it's meth residue of some sort?
I don't know what it is, and it could have happened when the door was opened, if that's on that same door,
It could have happened when the door was open,
with the door check.
with the door shut. Okay, could happen. But you have certainly objective evidence that there's powder on that window.
There is something white on that window. I'm not certain what it is.
Okay, let's go to exhibit number 2730. That was 2733, I believe, but.
2732.
Okay, 2733, let's go to 33. I got my numbers switched up, sorry. That shows a smudge on the door, doesn't it?
I don't have anything on my screen. I'm sorry.
Oh, well, we'll give you a moment here. Or I can have you look at the main screen here, whatever's easier.
And are we talking about the frame of the door?
Yes, correct.
There's something there. I don't know what it is.
And that would be objective evidence, right?
It could be objective evidence of him being hit by the door. It could be objective evidence of, again, it's a picture. You can't change it, so it's objective in that sense.
Let's pull up exhibit 159.
I don't have it yet.
I don't either. So, oh, there we go. We have it over here. You have it now?
Yes.
Okay. What's that show?
That shows a package on the ground. I don't see the white on the window in that one.
Yeah, this is several
So
What do you show, a white package? Is that a donut box?
it looks to be a intact, again, I can't see the top of it, but it seems to be some kind of box, and it could have been, I know there's donuts mentioned in the materials.
Right, well, you know, in fact, from the materials that you reviewed, that Ellis apparently was at a 7-Eleven within a half hour of this event purchasing donuts and a jug of water, do you not?
Absolutely.
Okay. So that would be objective evidence, potentially, that he was by the door of that vehicle, correct?
Well, I don't think there's any question, I don't think that's in dispute, because I think the officer acknowledges that he hit him with the door.
And the powder on the window is objective evidence that it potentially came from that donut box.
Well, again,
Or actually, Mr. Ellis's hand who had a donut.
I don't see the powder on the window in this one.
This is a different time frame, but you saw it on the other one. Let's go back to 2732.
It's not back up yet.
You see it now?
No, it's not up yet, I'm sorry. But can you put it in context, which picture was taken before and which was taken after?
That's it. I'm asking you about this.
I see it, I see white powder there.
All right. And you have all the materials that you reviewed, the only thing that would make sense circumstantially is that white powder came from those donuts in that box with Mr. Ellis had in his hands at one point, correct?
I don't know the answer to that. Again, there's some pictures that don't show it, there's some that do. It's treated as a crime scene, so you wouldn't expect anybody to wipe it off for the second picture, but I can't say for certain which picture was first, which one was second.
You'd agree that there's no evidence that it can be anything other than powder from a donut, from what you have reviewed.
I don't know the answer to that. I mean, it could be,
Mr. Ryan, what have you reviewed that says that cocaine, that's powdered cocaine?
no, I haven't reviewed, nothing to say it's powdered cocaine, no.
What do you have, what you reviewed, that suggests that it's any other kind
This
of
has
powder?
not been asked and answered.
Yeah, I mean, I don't know what it is, and I don't know why it's in one picture and not in another.
Okay. So you don't think that's objective evidence?
I don't think you can say what it is, what the substance is. I think the picture is objective evidence because it can't be changed unless somebody
And of
tampered
course,
with it.
what you teach, as part of a case, if the authorities, for whatever reason, lack of evidence, correct?
Of course.
That's right, of course. And so if someone didn't test the substance and you come up here and say, well, we don't know what it is because it wasn't tested, that's evidence or lack of evidence you use against the prosecution in this case because it's lack of evidence, correct? That's what you teach.
Objection, Your Honor. Argument.
I agree, it's argumentative.
Thank you. Now, you indicated yesterday on the use of force that, well, first of all, going back to the taser, you said it's discouraged to use tasers multiple times, correct?
Correct.
It's not prohibited, however, correct?
No, there can be circumstances where multiple deployments would be appropriate.
Okay. And you've been in situations when you were, or have you, when you were an officer where you used tasers on multiple occasions?
Not as an officer,
Okay.
but certainly I've been involved in audits as well as cases where multiple deployments have occurred.
Okay. And then, I think you did a little bit on direct, you talked about a person maybe not able to hear things when they're engaged in an episode such as we have here, correct?
Officers often get what they call tunnel vision, and auditory exclusion because they're focused on an individual, so they don't hear other things around them. So that does happen because they're focused on the individual.
And I think Hallamore, who was the next, did you look at Hallamore's materials in the context of your analysis evaluation?
I don't know the answer to that. I'd have to look at the list.
And let me say, you also have here testimony from various sources that the officers, Burbank and Collins, and I'm going to read to Burbank at the moment, that he was exhausted, correct? He was gassed.
I think that some of the officer statements say that, and I think he says that.
And actually, Hallamore notes that in his work in this case, does he not? Have you seen that?
I don't know that I've seen it. I'd have to look at the materials. I don't have it memorized. Certainly, if you want to show it to me, that's fine.
Well, I think we can do that. See if I can find my transcript. I apologize, Your Honor. Write this stuff up here. Yeah, I'm with you, too. If you can show Mr. Ryan Exhibit 2926. And just for Mr. Ryan. Sean, let me know when you have it up for him. Is up?
It's not. Well, it looks like it's coming up now. It's not here yet, but it looks like it's coming up. There we go.
If I could have you, Sean, if you can go to page 35. Is that in front of you at the moment?
Yes.
And if you go down to lines 22 to 25, and actually into the next page, 26, you just read that to yourself through line 2 of the following page.
You'll have to go to the next page. I'm ready. Yeah, I don't know who they're talking about. It doesn't say.
Okay. Well, it's been referred as being Mr. Burbank, so.
Okay.
And it indicates, Mr. Hallamore acknowledges that at least at one point on his work, he was having a difficult time understanding Mr. Burbank, and indicates he was clearly out of breath with labored speech, correct?
That's what it says. There's again,
You don't dispute that, do you?
I don't dispute it. No, I can't. How
Would
can I?
that be,
How can I dispute what he said?
Would that be objective evidence or subjective evidence?
Well, that's opinion evidence of this particular witness.
Okay. Of the expert witness that the state put on.
Correct.
Now, during the course of this struggle with Mr. Ellis, you indicated, first of all, your testimony is if you accept the officer's statements, he certainly had a right to arrest him. That's what your testimony was. Correct?
Absolutely.
And then they get in this confrontation. We don't know where it starts, right?
Well, again, we know that the officer says he door checked him with the door, so the physical confrontation would be at that point.
Right. Well, Well, we don't know what, my question for you, you're not suggesting in our interviews, you didn't suggest that the videos, all of the videos, show everything.
No, not at all. Obviously, we don't see him walking down the sidewalk in videos. We don't see him in the intersection in the video, so we don't have video of either story.
And the people who put them in the intersection, other than or Officer Burbank and Officer Collins, is Ms. White, Manling White, correct?
Puts him on the street. Doesn't necessarily put him in the middle of the intersection where there's a car turning.
Okay. She indicates, if we can pull up exhibits. Oh, 166A. You see that?
Not yet. I see it now.
That's a photo of the police cruiser,
Correct.
and there's two circles there.
Yes.
And that, based on prior testimony from Ms. Manling White, that's where she had the first circle by the headlight was where the officer that she saw, she didn't know the name, was situated, and Mr. Ellis is the one that's just on the side of that.
Absolutely.
And as she acknowledged, she couldn't see in front of the patrol vehicle down below.
Put that in context, please.
You don't know from the observations from what you call the civilian witnesses, you're aware that their viewpoint would have been obscured, whether it was Ms. McDowell from behind the vehicle. She couldn't see in front of the police cruiser, could she?
Right. You can't see through certain aspects of the car.
Right. And as Ms. Manling White testified, she couldn't see at least part of in front of the grill of the police car.
Correct.
And so what happened there, we don't have a video of what happened immediately upon that part of the event.
No, we have videos of certain points in time that the officers have described in their statements that when you match them up, that would be the positions.
Right. And Ms. White has the positions that are consistent with one of the officer's statements, right?
Again, if you're referring to being in the middle of the intersection, no.
Okay.
But if you're talking about being in the street, then absolutely.
Okay. And are you aware of the testimony from the experts here about there was movement into the intersection of several feet that they were able to map out, I guess, my words?
Well, I think there's several feet off the sidewalk.
Okay. Well, I'm talking about the middle of the street into the intersection.
You'd have to show it to me. I'm not sure of that.
Was the car, let me ask you this, from what you saw, would a person be able to open their car door and hit a person who's on the sidewalk?
Not based on the position of the vehicle there.
Okay. Any reason to believe that's not the position of the vehicle?
No, I think that's accurate.
Okay. Now, the force, by the way, the force used here, you're not saying it was deadly force, are you?
No, I'm not.
Okay. And we distinguish between deadly force, which is, as you indicated, in part a gunshot, for instance, that'd be deadly force.
A gunshot might be deadly force.
Okay.
Strikes the head with an impact weapon would be deadly force.
What we have here is intermediate force, correct? Would you agree with that?
Well, I think you have to say the taser is what they call significant intermediate force. So that's quite a bit different. It's what I was making reference to earlier.
Okay. Well, they don't distinguish it in the Tacoma PD policy as significant intermediate. They just call it intermediate force, do they not?
Correct, but the Ninth Circuit, which they fall under, calls it significant intermediate force.
And as is in the Tacoma policy manual, deadly force is, which you've looked at, is the use of any force that is likely, and the key word is likely, to cause death or serious bodily injury, right?
Correct.
And then deadly force does not include force that is not likely to cause death or serious bodily injury, but unexpectedly results in death or serious bodily injury.
I didn't, I think you misread the second part, so I apologize.
Roll up exhibit number 301 that was just submitted here a bit ago on page 9. Page 9 of that exhibit. If you go down to the bottom of that page, the second paragraph under subsection F, the last paragraph. Did I read that correctly or not?
Yeah, I think you might have skipped it because I didn't hear it. Does not include. I didn't think you said the not.
Deadly force does not include force that is not likely to cause death or serious bodily injury, but unexpectedly results in death or serious bodily injury, right?
Correct.
Which is the situation here. Would you agree?
No, I wouldn't. I wouldn't agree because of the.
And that's yes or no.
No, I don't agree.
Okay. So now you indicated that the officers are taught not to put weight on an individual.
Absolutely.
Never under any circumstance.
There can be brief weight, but never on the center of the back, never on the head, never on the neck.
And that's what you teach.
Absolutely.
Okay. And but weight can be used.
Weight can be used to stabilize somebody briefly in order to accomplish handcuffing,
And the
yes.
issue under using weight is whether it's necessary or unnecessary weight. Is that fair to say?
Whether it would be necessary and reasonable under the circumstances.
And you indicated one of the concerns about putting weight is a person developing hypoxia,
Correct.
which you're not a doctor. You agree with that?
I agree, but we do train that if the person can't get enough oxygen, their body shuts down.
Right. And you rely on the medical field to give you opinions as to how that happens and when it happens, what the concerns are. Is that fair to say?
I think we've been training it for at least 3 decades.
That's my question.
But
you're relying on the medical profession to tell you the dynamics of how.
well, obviously, some medical has to tell us that the body gets deprived of oxygen, the body dies.
And when you were interviewed by the defense with the prosecutor present, you indicated that a lot of officers that you train don't understand how hypoxia works. Is that right?
I think there's officers that don't understand the phenomenon of hypoxia. I would agree with that.
And you also indicated a lot of officers, a lot of people in general think because a person can talk, the officers think they're able to breathe, correct?
That's what we train, that's one of the biggest myths in law enforcement, that it's a myth, so we train them that that's just not true.
Okay. But it's still out there today, and you still train them, is that right?
Well, we have an officer that made a statement like that in this case.
Well, I'm just talking general terms. Right? And in fact, in our interview, you indicated that, sometimes you got to make an assessment whether this guy's telling the truth that he can't breathe or is it's going to be a ruse, right?
Well, I think what I said was that you always err on the side of doing an assessment of their physical distress. So you err on the side that they are telling the truth.
Right. Well, you err on the side of, first of all, protecting yourself. Right?
From a person that's already handcuffed and
we're not there yet.
Okay.
We're not there yet. Before he's handcuffed.
if a person said, well, obviously you've got to get the scene stabilized. So,
When you say get the scene stabilized, what you mean is get him, in this case, Mr. Ellis, under control.
in handcuffs.
In handcuffs. And so before he's in handcuffs, when they're struggling to put him in handcuffs and he's resisting, and if that's when he says, I can't breathe, they still got to get him in handcuffs. We'd agree with that.
If they have enforcement authority to take him into custody, then they've got to get him secured first.
And then they worry about, once he's secured, getting him into the recovery position.
As soon as they're handcuffed, they should be put into a recovery position immediately.
And we talk about recovery position, I think the term's kind of changed, position of comfort, right?
No, I don't. haven't heard that.
Okay. Well, some individuals, they don't want to get in the recovery position. Is that fair to say?
Well, I think you could have a person that resists that, but it's your responsibility to get them into that recovery position, get them off their stomach.
Well, that's sometimes easier said than done.
Well, it can be unless you have multiple officers there, sure, if you were by yourself.
Right. And eventually multiple officers come,
Well, I think there's already 2 officers there from the get-go
and they were struggling.
on their version of events,
Okay,
yes.
well, I mean, do you deny that there's the live and video that we watched here yesterday and other times? Are you saying that doesn't show a struggle?
It certainly shows that movement on the part, squirming, moving around.
Okay. Do you know when the officers arrived here, the other officers?
I don't have that in front of me.
If we can pull up Exhibit 25, well, strike that. The number here. I think it's 898. Pull that up. And by the way, when we talked about the recovery position, of course you read, as you indicated, Burbank actually, in his interview, told him to put in the recovery position, Mr. Ellis in the recovery position, did he not?
I know there was discussion of the recovery position. I just don't have committed to memory. He may have.
You don't recall it at this moment?
I don't. I recall Officer Rankin saying that he put him in the recovery position briefly to do the search, but I'd have to go back and look at it.
When you have this exhibit in front of you, 898?
Yes.
Okay. Do you know, by the way, do you know when Officer Burbank and Collins, for that matter, disengaged from Mr. Ellis?
It would have been sometime when I think Sergeant Lim arrived.
Because he wanted to talk to him by the car, right?
Correct, to do a use of force investigation.
And then Lim arrived at 23, 24, 44, according to this exhibit, correct?
Correct.
Was he already in the recovery position at that time, to your knowledge?
He was not. He was not, based on the statements of the officers.
What time was he in the recovery position?
When the fire department pulled up,
And when did they arrive?
I think it's like 8.5 minutes after the beginning of this.
Well,
I think that's the total.
What about in relation to when Lim arrived, do you know?
You know, I read Lim's statement. I think Lim says that it took them about 10 minutes to get there. I think he says that in his
I
statement.
don't want you to guess if you don't remember.
No, I believe that's in his statement.
I just have a moment, Your Honor.
Sure.
I think I'm done at the moment, Your Honor. I'll let Mr. Osler continue.
Okay, Mr. Osser?
Good morning. I'm good. How are you?
Hanging in there?
Absolutely.
All right. You were not the first use of force expert hired by the Attorney General's office in this case, were you?
I don't know the answer to that. I know that there was some discussion in my interview about another use of force expert.
So you're not aware that the Attorney General's office hired Sue Peters a retired King County Sheriff deputy on February 4th of 2021 to offer an opinion about the use of force related to this case?
Again, I have never seen a report. I think I made that clear in my interview, so I don't know the details of that.
So the Attorney General's office didn't share that information with you?
Not a report.
Well, okay, we'll talk about the report in a second. Did they share with you that they hired Sue Peters to offer a use of force opinion about the totality of the Tacoma Police Department's use of force in this incident?
I don't think that I ever knew it was specifically on use of force, but I do know that it came up at my interview that there was another person hired.
Okay. And that other person was hired before you, right?
I'd have to look at dates, but I think that's correct.
Well, with the court's permission, I'm going to hand you 2698. Is that okay, Judge?
Proceed.
2698 is a contract with the Attorney General's office with respect to Sue Peters, is it not?
Objection, Your Honor. Witnesses testified he has no information regarding her hire date or the report.
You said he'd have to look at.
I don't know, he can look at it, I don't know if he's ever seen it before. He can tell us if he hasn't.
I've never seen this before. What I meant was if I could compare my contract with this contract, then I would just compare the two dates and I would be able to give you an answer, but I have no knowledge of this.
Well, you're familiar with your contract with the Attorney General's office, correct?
I would have to look at the date on that because I don't have it committed to memory, but if you have it,
You weren't hired until November of 2021, correct?
if that's the date on the contract, that would be absolutely correct.
And your contract looks almost identical to Ms. Peters' contract, does it not?
Objection, Your Honor. This witness has testified that he has never seen this contract.
Well, you could ask her, certainly, if it's nearly identical to Exhibit 2698.
Do you have a copy of mine? Because then I can make a comparison.
We can certainly find that. Approach Judge and show Mr. Ryan his contract, which is Smart Defense 2701.
701? Okay,
Thank you.
proceed.
To commit with 2701, Mr. Ryan.
I mean, these.
Well, I haven't asked the question yet.
Oh, yeah.
2701 is a copy of your contract signed with the Attorney General's office to offer an opinion about the use of force by the Tacoma Police Department in this case. Is that right?
To review and have opinions which I obviously did.
Sure.
Yeah.
And your contract is almost identical to Ms. Peters' contract, right?
They look like standard state contracts. That's why I had to look at it because this is not usually what I do. It's an unusual contract even for me.
Right, because you usually do civil litigation as opposed to criminal litigation, right?
Well, even in the criminal, normally what happens is that we use my standard retainer form as opposed to a state contract like this. This has to be according to some state rule.
Right, and the scope is outlined in your contract, right, to review and offer an opinion about the use of force in this incident, right?
To review and to give testimony if they chose for me to, which obviously they did.
The same scope that's in Ms. Peters' contract, right?
And I don't see where and again, maybe I'm just missing it, but I don't see where it says anything about use of force on either one. So if you could point that out to me.
May I approach Judge?
And I apologize, I'm just trying to save
What I'm
time.
trying to do is scope of work.
Right.
You can point out, if you care to.
Well, you understand that Ms. Peters is a use of force. Is a use of force expert in the state of Washington, right?
Objection, Your Honor. He's already testified he doesn't know anything about this.
Doesn't know anything about the contract. I don't know if you know anything about Ms. Peters.
Yeah, I don't know the answer to that if she gives regular testimony on use of force.
Well, have you seen the declaration for determination of probable cause in this case?
I'm sorry?
Have you seen the declaration for determination of probable cause in this case?
If it's in my list of documents.
Can I approach, Judge?
You may.
I'm going to hand you 2518. You know what a declaration for determination of probable cause is, right?
Sure.
2518, I think.
2518, sorry. Turn to page 19 of 2518.
What page, I'm sorry?
19, please.
Page 19, you said.
Sorry.
I know it's long.
Yeah.
You see the caption, use of force,
Yeah.
expert?
Yeah.
I'm gonna object to this line of questioning from this document. This is not in this document, in the context of it. I mean, the contents of it are not admissible for the purposes of trial. Not
The question that I think we're getting to is whether or not, since he reviewed this, did he not notice that Ms. Peters was identified as a use of force expert by the state in the Declaration for Determination of Probable Cause? I think that's where this is going. And if so, that's fine.
That is where I'm going, Judge. The declaration of determination.
I get lucky now and then. So, objection overruled. You may consider.
The declaration for determination of probable cause authored by Ms. Eakes and Mr. Liu indicates that Sue Peters was hired as a use of force expert, at least as of the time that was written in May 27th of 2021, right?
It has that in here, yes.
It includes her opinion about the use of force relative to Mr. Officer Collins and Ms. Officer Burbank, correct?
You know, I'm going to object on regardless. Mr. Ryan hasn't relied on this. He's not known of her opinion. There's been no showing of her report to Mr. Ryan.
Well, we're going to get there too, Judge.
Well, I would say I'll sustain this particular objection.
Have you you've not seen Ms. Peters' report?
I have not.
All right, well, I'll show you that with the court's permission. 2700.
Your Honor, again, I'd object.
Well, well, hold on just a second here, everybody. So, Mr. Ryan, you did see Exhibit 2518, the one that was just shown you.
I don't know if it's on my list or not, Your Honor. I'd have to go through it.
You don't remember it? Is that
I
what
don't
you-
remember it.
Okay. All right. You want to be heard outside the presence? We'll do that. Ladies and gentlemen, please excuse us. Please do not discuss the case. Okay, does anybody want to allow Mr. Ryan the opportunity to look at his report to see whether or not it was part of the things he reviewed? Or however else he would ascertain that?
If he needs to, I don't know.
Anyway, so you wanted to be heard outside the presence, Ms.
Your Honor, I have
Nicolao?
some concerns about where defense counsel is going with this, and that, if he wants to call Ms. Peters or whatever route he wants to go, he certainly, and I understand he's subpoenaed her, or someone from defense has, they can certainly go that route, but going through Mr. Ryan in an attempt to either impeach Penn or to bring in her opinion is improper, especially Mr. Ryan did not rely upon her opinion. He did not review her report. His opinions are based on his own observations, and they have different scopes for which they were obtained or retained, which I know
Were their scopes different?
disagrees with the interpretation of it, but it's not relevant to the jury for the purposes of this witness. I mean, he's not here to testify about another witness. He's not here to go through another expert's position or review their observations.
Do you want Mr. Ryan excused while we have this conversation? Okay, Mr. Ryan, please excuse us.
Yes, sir.
Appreciate your patience, Mr. Ryan.
No worries.
I'm having a hard time hearing everybody. It's just the thing that, yeah, the speakers are, when you guys are talking, the speakers are off. Sorry.
Well, unfortunately,
We
it
got-
picks up too much and then it doesn't pick up enough, so we go back and forth.
Sound better, I can hear you too.
Yep.
All right, so, well, I agree with Ms. Nicolavo in the sense that I'm not, whether you, once it's pointed out that he's aware of Ms. Peters having provided work here, what, beyond that, what's the point of this?
Well, Judge, I find it impossible that following the defense interview where we asked him specifically about this, the state didn't provide a copy of their first expert's report for him to review, because it's wholly inconsistent with his opinion. And so I think I'm entitled to suggest that there's another expert he's aware of, at least when we interviewed him, that he was never then provided that report. He never reviewed that opinion. He is aware that that opinion is inconsistent with his because we asked him about it, and he apparently chose not to look at that for purposes of determining whether that changes his opinion. And I think the timing is obviously concerning about when they're hired relative to when they do draft reports. I think I wrote a motion to dismiss based on this conduct, wherein the state hired Ms. Peters. She wrote a draft report that the state withheld from us intentionally until after the defense interview of Ms. Peters. After the interview, Mr. Liu said it was work product, which it's not, and then provided it. Come to find out, they hired this expert. In November, Ms. Peters then changes her report and takes out the portion with respect to Collins and Burbank because it's inconsistent with his opinion, and then limits the scope to officer ranking, which is inconsistent with the Declaration of Probable Cause and the scope of her contract. How that doesn't go to his credibility, I don't know.
Well, I'm not sure it goes to his credibility unless you can show that he in fact was aware of her changed report. It may have something to do with the state's motivations here, but not necessarily the witnesses.
Well, Judge, we asked you specifically about this in this interview.
Right, and I suppose you could go to that point and say, you were asked us about this in your interview, whenever that was, and that didn't, and you recall that, and so maybe you do or you don't, we don't know what his answer's going to be, and then if he doesn't, presumably you'll refresh his recollection one way or another about that, and then if he does, he'll go, and after that, you didn't have curiosity to look into it?
We can do that with you, Judge.
I mean, is that what I can see where that's going, but if in the end he didn't consider it, he didn't consider it. And you can maybe make that sound incredible or not, I suppose. But if you did consider it, well, then obviously you can talk about it. But we have to get to, I'll allow you to get to that point, but I'm not gonna, I sustain the objection about, you're asking a question about Ms. Peters' opinions in the Declaration for Determination of Probable Cause. Because I don't want to necessarily, I think it's something of a collateral matter at this point at least. Mr. Conrad's risen to.
I'll ask it a different way, Judge.
Okay.
I can ask if he's aware of her opinion for certain based on our conversation.
Well, in a way, I think he said he wasn't, actually. At least he said he didn't read a report, or never saw her contract either. Anyway, Mr. Conrad is about to fill the room with his intelligence. Go ahead, Mr. Conrad.
Not true. Just an observation. I think that the probable cause statement is self-authenticating because it's,
Self-authenticating?
well, it's a court record, right? So,
Well, yeah, but that's not necessarily, just because something's authentic doesn't mean it's going to go in front of a jury.
sure, understood.
So,
Obviously not that wise.
oh, okay, well. Anyway, are we ready to have the jury back? Do we know where we stand? Are there any other questions about all this?
Well, I'll follow up in compliance with the court.
That would be good.
The court just what?
Directed, certainly.
All right, I guess we got the jury back. Ms. Nicolavo, you were looking kind of funny, so I'm wondering, are you ready for the jury?
I'm always looking funny, Your Honor.
Kind of this resting face I got.
Well, funny's maybe the wrong word here, but
Okay.
anyway,
Okay.
disconcerted, I guess. Is there an issue?
I am certain that Mr. Osser will follow the direction of the court.
I'm open for that too.
If there is
All right, let's have the jury.
Minor detail.
Shall I go get Mr. Ryan?
Yes, please. All right, welcome back, everybody. Please be seated. Resume when you're ready, Mr. Usher.
Thank you, Judge. You recall being interviewed by defense in this case,
Yes.
and during your defense interview, we asked you about your opinion and whether you knew about Ms. Peters' opinion. Do you remember that?
I remember it coming up. I think I brought it up earlier.
Yeah.
But I don't, I never had her report. I didn't.
We'll get there. I just
Yeah.
want to make sure that you understood at the time that we interviewed you that the state had hired an expert before you to offer the same opinion, right?
I didn't know if it was what it was, the purpose was.
Okay.
So I had no idea it was to, at that time, I'm certain that I didn't know what the opinion was or anything like that.
Okay, but you knew that, at least we were inquiring about whether you knew that she had offered an opinion that differed from yours. Do you remember that?
I knew you questioned me, or somebody questioned me about whether I knew that there was another expert hired by the state in the case.
Okay, and you were asked, well, after that interview, did you inquire of the Attorney General's office about whether they hired somebody else that offered a different opinion?
Not at all.
Why not?
Because, you know, there's cases, for example, I've been hired by the Attorney General of Minnesota recently to look at a case, not for purposes of getting involved in the actual case, but to consult early on as to whether or not a prosecution would be brought.
Okay, so if Ms. Peters offered, Ms. Peters offered an opinion that Officer Collins and Burbank's only violation was
Objection, Your Honor. He's not been made aware of her opinion. He didn't rely upon her opinion. Her opinion is irrelevant through this witness. And certainly, it's everything we just went through.
Well, Judge, I can ask if you knew this opinion, would it change his opinion or assessment in this case?
Well, let's not go into the substance of whatever her opinion was, I suppose. At least not at this point.
All right. If you were aware, not the specifics of her opinion, but that her opinion differed with yours, about any violation.
Objection to the characterization of it, Your Honor.
I'm going to allow this question.
If you learned that her opinion with respect to the use of force by Officer Collins in Burbank was different than yours, could it change your opinion in this case, or would you at least consider it an evaluation of your opinion?
No, because I had all the material, and I had the videos. I had the officer's statements. I had the witness's statements. So another expert's opinion wouldn't change my opinion.
Because expert opinion in this regard can change depending on who's hired them, right?
Objection.
Overall,
Right?
Say that again?
The expert opinion on use of force can change depending on who's hired them, right?
I think with some experts that may be true. Certainly not with me.
So you indicated that you didn't necessarily need to review Ms. Peters' report because you had access to everything that you thought was necessary to form an opinion. Is that fair?
I think I had access to voluminous items, and another expert's opinion wouldn't impact mine.
Okay. Some of the things that you had access to, Mr. Ryan, were the voluntary statements of each of the officers who were on scene on March 3rd of 2020, right?
I did. I had statements of multiple officers.
So you know that each one of those officers provided voluntary statements to the Attorney General's office in this case?
Yes,
And you reviewed every single one of those, right?
I did. I had a whole, they're on my list of the ones that I did review. Absolutely.
That included Officer Masai Ford, right?
Yes.
Officer Masai Ford was Officer Rankin's partner and arrived at the same time as Officer Rankin in this case, right?
That's correct.
Sergeant Gary Sanders
Correct.
arrived shortly after both Ford and Rankin, is that right?
Yeah, I'd have to look and see if he was next on the scene, but I think I've incorporated that in my report.
And Sergeant Sanders was not employed by the Tacoma Police Department, was he?
Correct. He was employed by the Sheriff's Office, is my understanding, Pierce County Sheriff's Office, I believe.
Separate agency, right?
Correct.
Sergeant Lim, which we just saw the Exhibit 898 published, was on scene about 24 seconds after Officer Rankin. You remember that?
I think that's it. Well, that's according to that exhibit, yes.
According to the catalog that was referenced in the exhibit.
Correct.
And you understood that Sergeant Lim was the direct supervisor of Rankin, Ford, Collins, and Burbank, right?
Yes.
And then Sergeant Rock appears within, I don't know, 15 seconds of one of the next.
I'd have to have it back in front of me, but I certainly wouldn't dispute the times.
It's documented in 898, right?
Correct.
All right. And he also was a supervisor of Officers Collins and Burbank. You're aware of that? Sergeant Rock, sorry.
I thought it was Lim.
Well, Lim's responsible for one of the units and Rock for the other. Are you aware of that?
Okay.
There's two sectors involved here.
I didn't recall that, but
All right. Both sergeants, though, you understood that?
yes.
You understood that there was Officer Bucat from the Lakewood Police Department who arrived shortly after as well. Is that right?
Correct.
Third agency involved at this point.
Yes.
You understand that Casey Jones, a Washington State Patrol trooper, arrived about, at least in the timeline, a few minutes after Ford and Rankin.
At some point, I was aware that somebody from the state police responded. I didn't remember the name.
That's fair. So four separate agencies, were on scene before Mr. Ellis is treated by medical staff. Would you agree with that?
Yes.
You reviewed all those statements, right?
Yes.
Including Casey Jones.
If it's on my list, I'd have to go back and look, but you should have my list.
I do. Can I approach Judge? Yes. I'm going to show you 822. Is Officer Jones, Trooper Jones, which you reference in the statements that you reviewed. Do you remember seeing that report?
Just let me look at it, please.
Of course.
I'm sorry, Mr. Foster, what exhibit did you provide me? 822?
Okay.
Have you seen that before?
I have. I've seen a number of these statements.
Okay. And you considered that in coming
Of course.
And you're aware then that Trooper Jones arrives after Mr. Ellis has been placed in hobble restraints, is that right?
Based on the time.
Yeah. Because he shows up at, well, it says in the report. What time does he show up?
He says 23:27, which would be 11:27 at night.
Right, and we saw that in 898 that was just put up on the screen, the timeline. Did you remember seeing that?
Yes.
And he describes Mr. Ellis even after hobble restraint and cuff restraint, actively smashing his face into the ground, right?
He reports that he was screaming and appeared to be striking the pavement with his head.
All right, that's not the sort of conduct that you described on direct examination as air-hungry conduct, right?
Well, it absolutely could be. It could be. A person's fighting for breath. They make all kinds of involuntary movements, so it absolutely is.
Well, you understand, based on the timeline that you reviewed, that Mr. Ellis was talking and turned onto his recovered position even after this account by Trooper Jones, right?
According to Officer Rankin, he was finally turned into a recovery position as the fire department was pulling up. There is a period of time when he does a search, and he turns him on his side to do the search as well.
Earlier in the...
Correct.
All right. And so, is it your opinion then, Mr. Ryan, that what's described by Trooper Jones is involuntary air hunger conduct by Mr. Ellis?
It absolutely could be.
It could also be Mr. Ellis continuing to be combative with the officers, even post-restraint, right?
Well, I mean, he's got handcuffs on, hobble. The hobble is connected to his wrists on a 90-degree angle, and he's got officers putting weight on him, and he's prone on his stomach. This also reports that he's still prone on his stomach.
Well, that doesn't indicate that there's an officer on him, does it?
No, it does not. But we know that we have Officer Rankin's statement that says that other than that brief period of time, he stays on him until the fire department gets there.
Okay. Well, he says he has his hands on him at certain points as opposed to his body weight, right?
No, I think he says body weight for most of it.
So your understanding is that Officer Rankin is just sitting on Mr. Ellis as 4 other agencies are watching him fight for breath?
Well, there's certainly, if you read his statement, and obviously you have his statement, you'll see exactly what he said.
Well, you've reviewed the statements from those officers I just described from 3 other agencies. Not one of them says Officer Rankin is sitting on his back while he's fighting for breath, do they?
Absolutely not. I don't see that in their statements.
Just discount that then?
No. Officers are doing brief statements as to what their involvement was when they got to the scene. And they do give some descriptions of what they say they saw. There's no question about that.
Mr. Ryan, you would expect an officer from the Washington State Patrol who's not related to TPD to articulate that he sees a TPD officer sitting on somebody who's in prone restraint fighting for breath as he's just sitting there watching, right?
If that's the observation he made while he was having a conversation with this other officer, this Lakewood officer, which is what he reports, that he's standing talking to this Lakewood officer, if he were to see that, then yeah,
Well,
he should actually intervene.
of course he should, right?
Absolutely.
And of course he should document, I see Officer Rankin sitting on him while he's fighting for breath, right?
If the officer knew that, made that observation, then absolutely he should actually intervene in that.
Well, if we take your opinion, Mr. Ryan, based on Officer Rankin's statement, Officer Rankin's sitting on his back the entire time, right?
Well, I think you'll look at his statement and see what he says, because he says at several junctures that he's got a knee up by his neck and a knee in the center of his back. That would be consistent with that.
All right, and you would expect officers from other agencies to account for that in their reports?
If they made that observation, certainly should have, and I think they would have an obligation to intervene in that.
So it sounds like Pierce County Sheriff's Department failed in their obligation to document that, right?
If it's not in their statements, it should have been documented.
Lakewood Police Department failed in their duty to document that,
Yes.
and Washington State Patrol failed in their duty.
Assuming they all have made that observation, yes.
We're assuming that that's accurate, right?
Well, we do have the officer himself, we have his statement, and you can read it.
Well, I've read it, but if that assumption is accurate, you'd expect those three other unrelated agencies to document that.
Absolutely should have and should have intervened if they made that observation.
And none of them did in this case, right?
Not that I'm aware of.
Judge, I don't know if this is a good time to break.
It is our normal breaking time, so we can take our recess now. All right, ladies and gentlemen, 15 minutes. Please do not discuss the case among yourselves or with anyone else. Chester, continue when you're ready.
Mr. Ryan, I neglected to follow up on your contract. I think we talked about Ms. Peters, but not your contract.
Okay.
You were actually connected to Ms. Eads in this case from an attorney named Julia Sherwin, is that right?
I think there was an email or something, introduction.
Yeah. With the court's permission, I'm going to hand you what's been marked as 2744. See if you recognize that.
Proceed.
Thank you, Judge. Does that look familiar, Mr. Ryan?
Yeah, I mean, I don't recall when, well, let me look and see where it came in.
You see the dates and times on those?
It says this was, like June 2nd when it was first sent, and then I responded just that I'd be happy to speak to her or look forward to speaking with her.
Sure.
With numbers.
Let me break it down, Mr. Ryan. I'll ask you specific questions. That initial email, or at least the one that's from Julia Sherwin, is to Patty Eakes, who's the Attorney General in this case, before you respond. Do you see that?
Correct.
And in that email, Ms. Sherwin provides the name of you, Dr. W., and Dr. Freeman as witnesses that can provide testimony in this case, right?
I think she, I mean, there's no way she would know if I could provide testimony. Certainly, she knows that I'm a police practices expert and that I could review and determine if testimony is appropriate.
And then I think you said you responded on top of that exhibit maybe a day or two later. Can you tell me the date?
Yeah, it looks like probably 3 days later, June 5th.
Just introducing yourself to Ms. Eakes.
I just provided telephone numbers to contact information.
Okay. And then I assume after that email communication that you and Ms. Eakes spoke at some point telephonically?
Yes.
And then you entered into your contract, I think in November. Do you have that in front of you still, just so we can get the exact dates?
Sorry, give me a second.
I apologize.
No, it's my fault. I moved them around.
Do you see your contract? Can you give us the exhibit number just so that everybody knows?
Yeah, it's Exhibit 2701. I'm just looking for the date. I don't know if it's at the end or... Yeah, it should be, right? But it's not. So I'll have to find it. So it looks like, and which is unusual, I don't usually sign them, but I signed this on November 24th,
Of which year?
2021.
Okay. So after charges were already filed in this case?
I don't know what date the charges were filed.
Okay, fair enough. And that document sets out your compensation for your testimony in this case, right?
Yes.
And that's $250 an hour
Yes, sir.
for a maximum of $20,000.
If that's in here, then I,
I think it might be on the first page, if not the second page.
it does say not to exceed 20,000. Yes.
Right. And then a $2,500 a day fee for testimony, right?
Correct.
$2,500 a day for interviews or depositions, right?
Correct.
And then $1,000 a day for travel related to any of those things, right?
Correct.
How much are you going to charge for your testimony and opinion in this case? Total.
I know I charged 53 hours on the initial review. I know that because I checked, because I thought you might ask me that.
And just so we're clear, Mr. Ryan, when you say initial review, that's the review up until you wrote your report?
Correct.
Okay, and then obviously, after writing that report, you've had to review a lot of materials, right?
I reviewed a lot. I'd have to go back and look at the number of hours.
Do you think it was more or less than the original 53?
No, I think it was less.
Okay, but somewhere between, so maybe between 50 and 100 hours, less than 100?
Total?
Yeah.
I think it'll be less than 100, yes.
All right. You can put that down now.
Okay.
One of the things that you reviewed, that you've talked about, is Officer Collins' transcript of his taped statement. Do you remember reviewing that?
Yes.
And you understand that that statement was provided March 9th of 2020.
That you'd have to show me. I don't have the dates
I
memorized.
assume that was going to be the case. May I approach, Judge? I'm going to show you what's been admitted for illustrative purposes, Exhibit 59A. You recognize that as a transcript of Officer Collins' statement on March 9th of 2020?
Yes.
Okay. And are you aware that that statement was given 3 months before any video evidence was ever obtained in this case?
I know there's a period of time before the video evidence came out.
And in Mr. Collins' statements, he describes Mr. Ellis going to the passenger window and striking the window multiple times. Do you remember him saying that?
Yes.
And Mr. Fricky put up on the screen, looked like some powdered sugar marks on the window.
Certainly with some white substance, yes.
Okay, fair enough. And you're aware that there were officers on scene that preserved that scene, right?
They certainly should have, yes.
But you reviewed reports that indicate that as well?
Yes.
Were you aware, based on your review of the evidence, excuse me, that Mr. Ellis had a laceration to his left pointer finger knuckle?
That you'd have to show me something. I don't recall that.
Okay, that's fair. You don't recall that specific photograph?
Correct. I don't recall that specific photograph.
Are you aware that he's left-handed? Did you learn that from the review of discovery?
I'm sorry, I don't remember that.
Fair enough. Regardless, you know that, at least according to Officer Collins and Officer Burbank's statements, that their account is that Mr. Ellis attacked the patrol vehicle in the location that we saw the white smudges.
Correct.
You're also aware then, based on Officer Collins' statement, that Officer Collins reported getting out of the vehicle and confronting Mr. Ellis to try to prevent him from continuing to attack his partner, right?
Absolutely.
And he described that interaction happening in the front of the patrol vehicle. Do you remember that?
I don't recall if he went all the way to the door or if he went to just to the front, and that drew Ellis's attention.
Fair enough. But what Officer Collins says is that once Mr. Ellis' attention was drawn to him, there was a physical altercation between the two of them at the front of the vehicle. Do you remember that?
Correct.
In which Mr. Ellis grabbed Mr. Collins by his tactical vest
Yes.
and then actually lifted him up and threw him into the area directly in front of the vehicle.
Correct.
You've seen photographs of injuries sustained by Officer Collins, have you not?
I think I saw pictures of him in his uniform.
Right. You observed the injuries to the back of both of his elbows, consistent with being thrown on your back on the pavement, right?
Well, again, it could be consistent with that. It could be consistent with any kind of scrape from the entire event.
Okay. Can't say one way or the other, but would be consistent with that account potentially.
If in fact he went on his back and that actually happened, yes.
Okay. All right. In Officer Collins' statements, Ms. Nikolava asked you about those yesterday. Do you remember that?
Yes.
What Officer Collins actually said was that he attempted to apply an LVNR, right?
That's what he says.
He never actually says, I applied an LVNR, does he?
Well, I think attempt could mean a lot of different things, but he certainly had his arms around the neck, because we see that in the video.
Well, we're going to get there. His account, before he knows there's video, is that I attempted to apply an LVNR, right?
Yes.
And he indicates in his statement that I attempted to apply the LVNR after the physical strikes, the elbow strikes, had no effect. You remember that?
That's correct.
And what he described during the interview before he knew there was video was that he mounted Mr. Ellis on his torso, correct?
Yes.
And he delivered multiple elbow strikes to his head.
That's correct.
And that none of those strikes had any effect on Mr. Ellis.
That's what he reported.
And he describes that as he's mounting Mr. Ellis is able to stand up from that position, correct?
I think that's what he reports, yes.
And actually comes up towards Officer Collins' face, right?
I think that's what he reports, absolutely.
In
Yeah.
fact, he has to move out of the way, and they both end up on their side facing the intersection, is how he describes it, right?
Correct.
Before he knows there's a video that actually shows that, right?
Well, I think that's the way he described it.
That's consistent with the video that we're about to watch, right?
It's consistent with the movements.
Well, let me say this. McDowell's second video and Cowden's video comes from the perspective where the officers and Mr. Ellis are facing Mr. Cowden's vehicle. Do you remember that?
Cowden's, or you just put the two together, and they're two different perspectives?
Right. McDowell drives by, right?
Correct,
And Cowden's stationary.
correct.
And they both pass in front of Mr. Ellis and the officers as they're facing the direction of Cowden. Is that fair?
Yes,
Okay. And in both perspectives, Officer Collins is behind Mr. Ellis as they're on their side, right?
I believe so, because obviously that's the way he starts to attempt the LVNR.
And that's what he says on March 9th before there's a video, right?
Yes.
From the video, the first McDowell video where we see the elbow strikes,
Yes,
you recall that?
yes.
To the next video that shows Mr. Collins behind Mr. Ellis. How did Mr. Ellis get out from being mounted on his torso?
Objection, Your Honor.
Sorry.
Objection. Calls for speculation.
Well, he can say that he doesn't know the answer to that.
I suspect that's what he's going to say.
Yeah, I mean, I don't see that on the video, so it's hard to say.
Right, there's a 10-second gap, right?
Correct,
A 10-second gap from Officer Collins mounting an individual who's on his back, right?
correct,
Delivering blows to the head area, right?
correct.
The next thing we see is both of those individuals on their side in the middle of the intersection, right?
That's the next thing we see, and he's attempting the LVNR.
Within 10 seconds, right?
I don't have the timing down, but I obviously, if you show it to me, if we could sync them up,
Yeah,
I wouldn't dispute it.
we will. Just a second. I just want to make sure that's your understanding as well.
Yes.
All right. And what Officer Collins actually says on March 9th is that I attempt to apply the LVNR, and I can only get my right hand to my bicep, right?
He does talk about where he's able to get his arms.
We'll turn to page 10, lines 16 through 24 of that exhibit, because he's very specific about what he's able to do and where his hands are.
What line, please?
Or sorry, that was too fast. Page 10, you see page 10?
Yes.
Lines 16 through 24, and go ahead and read that to yourself.
Well, he doesn't say he's only able to get it. He said he slides his hand around to where the bicep is. And before he can apply it, he sees his partner out in front, and he's got his taser out. And he hears the crack of the taser.
Right. So what he describes is I'm attempting to apply the LVNR, right?
Correct.
I'm moving my right hand up around the neck area, right?
Correct.
And I get it to my my left bicep.
He gets it that far.
And as soon as I get to that point, I see Officer Burbank with the taser, right?
Correct.
And so then he moves to avoid being hit with the taser, right?
I don't know that he says that.
Well, he says I come off the LVNR, right?
Right, because he says there's immediate neuromuscular incapacitation, which we don't see on the video.
Okay, so what he says is I attempt the LVNR, Officer Burbank deploys the taser, right?
Correct.
And that the neuromuscular takes effect,
Correct.
and that Officer Collins then says, I let go of the LVNR and attempt to get his left arm restrained, right?
I push him face down and then move to his left arm.
And we saw that in the video too, right?
What's that?
We see that in the video as well, right?
We certainly see the struggle to try to get the arms, yes.
Well, we see the officer put his head on the ground, right?
We see the head flop to the ground.
And he puts his left hand, meaning Officer Collins puts his left hand on the ground, right?
He puts a hand on the ground. I'd have to go back and look at it. I apologize.
We will. And then he goes for the left arm to restrain Mr. Ellis, right?
Correct.
And he says that before he knows there's a video showing just that, right?
If the video's 3 months later, yeah, obviously.
The taser application, we've heard testimony already about what the purpose of that is and what the effect is. It carries a 5-second electrical shock to the person if the probes insert correctly, right?
If the probes enter correctly and if you've got enough probe spread.
Right. and that causes the neuromuscular tension that you talked about,
Correct, causes it to lock up.
followed by a short period of incapacity, right?
5 seconds.
Meaning they essentially lose consciousness or function at that point, right?
Well, not consciousness.
That's fair.
They lose function because they lock up.
Right, and they go limp, right?
Well, they tend to drop during that 5-second time frame if they're standing up, for example.
And then Officer Collins says that they struggle and they apply the taser two more times in order to actually get the handcuffs on Mr. Ellis, right?
That's what he reports. He actually, I think, are we talking Collins or Burbank?
Collins.
Collins says, I think that they get the handcuffs on after the second deployment.
I think you're right. I think he says after the second, and I think Burbank says maybe the fifth or something, right?
I think Burbank says the fourth.
Okay, all right. But we see it on video, right?
We do.
Parts of it. Is that fair? We don't actually see the cuffs applied, do we?
Well, you can't see that close to see the cuffs apply now.
All right. And then what Officer Collins reports is that even after they get the cuffs applied, Mr. Ellis is attempting to stand up and is able to stand up with both officers trying to restrain him, right?
Yes, obviously we don't see that, but
Right. There's no video of that, right?
there's no video that shows that.
But Shad Hayes sees it, doesn't he?
I think Shad Hayes says he is trying to stand up, is my memory of his statement.
Well, you have your report in front of you?
Yeah, I don't think I had Shad Hayes in my report.
Oh, okay. Well, Shad Hayes says, I see Mr. Ellis restrained, standing up with two officers, and he's throwing them around like rag dolls. That's what he says, isn't he?
He may say something to that effect.
Right. That'd be consistent with what Officer Collins says, right?
As far as,
As post-restraint, Mr. Ellis continuing to fight with them and try to stand up.
I think, and again, let me just look at it. I don't know if he said violently thrashing or if he said he tried to stand up. Can you point?
Officer Collins?
Yes. If you can point that out to me.
Yeah. I'm looking at that same paragraph, lines 15 through 24. Doesn't Officer Collins says, once we get him cuffed, he's cuffed, the fight's not over. He comes back at it again, starts growling. Now he's trying to stand up. His legs are going underneath him. He's trying to stand up.
And he's face down on the ground, handcuffed behind his back, and he's trying to lift himself up. So he's still face down on the ground.
Okay. Obviously, the officers have him cuffed while he's on the ground, right? Face down.
Yes.
And the account from Officer Collins is that doesn't stop Mr. Ellis from continuing to actively resist being restrained, right?
That's Officer Collins' account.
Well, that's also consistent with Shad Hayes' description, right?
Shad Hayes also said he was trying to stand up.
All right. And then what Officer Collins describes is to combat Mr. Ellis from standing up, because that could create danger for Mr. Ellis, right? If he's able to stand up.
If he's able to stand up, I mean, he's still handcuffed, so his hands are immobilized, but certainly a person standing up can kick or bite or
fall on their face from 6 feet up and get a skull fracture, right?
could happen.
Right. And so the duty of the officers to prevent the opportunity for harm, right? At that point in time.
Well, anytime you take custody of a prisoner, you've got to prevent harm.
And you
So, yeah.
understand that the location that this is happening, there's cars driving by as this is happening, right?
There are a couple of cars.
Right. And so the officers cannot allow Mr. Ellis to stand up in that situation, can they?
No, that's why they put him on the ground, keep him on his side, get him up on his side, get him off his stomach immediately after handcuffing, and hold him to the ground in that fashion.
And what Officer Collins tells you once they get him handcuffed is, my response to him trying to stand up is I grab his legs and I cross them, right?
Correct.
And that's what he's supposed to do in that situation, right?
No, actually, you're supposed to put them on their side, and at that point, get them off their stomach.
Well, what if the person being taken into custody is resisting being placed on his side by kicking, flailing, or slamming his face into the ground?
Well, you can accomplish the same thing on their side as you can if they're on their stomach, and that's why we moved them immediately. It's been trained for at least 30 years.
And so what Officer Collins tells you is I grab his legs and I cross them at the knee, right?
Correct, and he stuck his leg in the back, so now you've got, again, maximal restraint on his stomach, which is problematic.
Well, that's not consistent with what the experts have testified in this case anywhere.
You'd have to point it out to me, but that's definitely maximal restraint under a police practices point of view.
Well, each of the experts has testified in this case that the application of weight to the legs has.
Objection, Your Honor, he's referencing medical testimony and not anyone that's police practices, and this is qualified statement in police practices, and this was here testified to, and the court restricted them to. Testified to, and the court previously restricted them to police practice, not medical testimony.
Overruled, may answer.
So you're not aware that the medical experts in this case have testified that the application of weight to the legs has zero impact on the effective respiration or expansion of the chest?
No, I mean, that would be a police practices position as well, but it's in conjunction with him being on his stomach. It's the combination of the two that is maximal restraint.
Well, certainly they're attempting to maximum restraint. I don't disagree with that, but my question is the process of crossing the legs to prevent standing up and restricting that movement is what the officer is supposed to do in that situation.
No, the officer is supposed to get them on their side and get them off their stomach.
And if he's not allowing them to do that, what are they supposed to do? Let them stand up and run away?
No, of course not. That's why they get them on their side. They stack their ankles, and they use the pressure that way, and that way it's not on the torso.
Well, you understand, you reviewed the entirety of the discovery, that it took 6 officers to restrain his legs sufficiently in this case, right?
I know a number of officers reported that they assisted in restraining his legs. It doesn't change the police practice of getting him on his side, and his legs could have been restrained that way.
Well, it does not affect your opinion at all whether they were able to do that with this individual?
Not based on the statements of the officers, no.
So you believe that 6 officers were violating police policy in failing to turn him on the side before restraining his feet?
I think every officer should have immediately got him on his side and got him off his stomach.
You understand that once they got Mr. Ellis actually hobbled, that Officer Collins was removed from the situation, right?
At some point, he was removed by the sergeant, yes.
Well, he tells you in his statement that as soon as hobbles are applied, I get up and leave, right?
I think, well, he says he got up and got off him, and he was trying to catch his breath.
Page 12, lines 20 through 25.
So I just stepped away. Shane and I both backed up. And they had control of the guy.
Right, and at that.
I think that's what he reports, but I don't see it where he exactly says that he was behind a patrol vehicle.
Okay, but you understand in reviewing the reports in this case, Sergeant Lim began interviewing my client about the use of force while Mr. Ellis is still being attended to by other officers.
I know Lim initially went right to where Mr. Ellis was, and then I know that he went and talked to the 2 officers.
And those 2 officers are Officers Burbank and Collins, right?
Absolutely.
All right, and at that point in time, Officer Burbank and Collins gave their account of what had just transpired, right?
They gave an account. They don't mention any breathing issues or those issues.
Okay. Indicating maybe they didn't hear Mr. Ellis say, "I can't breathe" during their fight with him, right?
Again, I can't get in their head and say what they heard, but I can say that if you can hear it from a doorbell from a distance away, they should have heard it.
Well, you just told us that you've been in altercations on the street where you didn't hear what was happening because you had tunnel focus, I think.
Right. I heard what the subject was doing, but I didn't hear things outside the framework of the subject because my tunnel vision is on the subject that I'm dealing with.
All right, fair enough. All right. Then what you know, because you've reviewed the entirety of the discovery and the interviews in this case, is that Officer Collins, immediately upon fire arriving, went to fire and said, "Get to him." He showed signs of excited delirium, right?
That's right. That's what his statement is, yes.
And that's consistent with training and protocols, right?
Well, certainly should have gone and told fire everything that he saw with respect to any kind of stated or observable disability.
Well, sure. You don't want to delay fire from getting to Mr. Ellis by telling them every single thing that happened, right?
You don't want to delay, but you want to give them sufficient information so they know how to treat the person.
Okay. And you understand that Mr. Ellis indicating he couldn't breathe, he indicated that to the other officers who were still present at the scene, right?
He indicated it at various times during the encounter.
In fact, Sergeant Lim is present on radio, calling for fire as he's saying it. You can hear it on the radio, right?
Sergeant Lim says in the statements that I read that he never heard it, but it is in the background of the radio.
Okay. With all the other officers who are now present, up to 12 to 15 officers, right?
I don't know what the exact number was at that point.
All right. So reason to believe they're hearing the same thing, I can't breathe, right?
They should have.
You have your report in front of you?
I don't believe that I do. What?
Paragraph 35 of that, if you will.
What did you say, paragraph what? Sorry.
35 of your report. It's on page 14.
Yes.
Doesn't Kenneth White confirm the account of Officer Collins about what Mr. Ellis is doing, even after being hit?
He manhandled the two officers who were on top of Ellis. White described that Ellis, while laying on the ground, was lifting the two officers. White said he did not see, and I think I've got a typo there, any fist or elbow blows, strikes. White said he could hear the taser being deployed.
All right, so White says, I hear a taser, I don't see the striking,
Correct.
but I see Mr. Ellis standing up with two officers on his back trying to restrain him, right?
I don't think he says he sees him standing up.
Well, he says he's able to manhandle the two officers who were on top of him. White described that Ellis, while lying on the ground, was lifting the two officers, right?
That's correct.
That's consistent with what Officer Collins said, right?
But that's not standing.
All right, fair enough. Still consistent with what Officer Collins says, right?
It's consistent with the degree of resistance, yes.
Earlier you said the collective force of this incident was contrary to TPD policy. You understand that these officers aren't judged on collective force, it's on their individual force, right?
Individual force, but if they're there together, all seeing the same force at the same time, then you take that into account.
Sure, but you know now that Officer Collins is removed from the scene post hobbles being applied, right?
Yes. I knew that then. I've got that in my report.
Yes. All right. Yesterday, Ms. Nicolavo had you review, I think we call them PDF still slides of both the McDowell video and the Cowden video, I believe. Do you remember doing that?
I remember looking at the PDF videos, yes.
And those are 30 slides per second captures of what's happening, correct?
I believe it's 30 frames per second.
We actually have the video, right?
Yes.
You've actually reviewed the video, right?
Yes.
And the video actually tells us or shows us exactly what happened, right?
Well, the video is moving quickly, so you can't see exactly what's going on. When you do the frame by frame and move it slowly, then you can see everybody's movements.
All right. And the video contains sound too, right?
Correct.
So we can actually hear what Mr. Ellis is saying and doing responsive to these acts by the officers, right?
Some of it, yeah, of course.
All right. One of the things that Officer Collins references in his interview, which is significant because when we consider the TPD policy, he talks about prior experiences with people exhibiting superhuman strength as he describes Mr. Ellis, right?
Just point it out to me.
I will. If you can
I know he mentioned superhuman strength, but I don't know that, I don't recall a prior incident.
go to page, well, I don't know what page it is on that. It's page 11 on mine. Can I approach Judge? He has a different format than I do. I think it's 59A. Can I see the exhibit number?
Sure.
590, okay.
59A, Judge. Let me see real quick. I'll find it faster. But. It's going to be page 24 of that exhibit. And it'll be starting on line 4. Do you recall reviewing a statement, or at least a description by Officer Collins about prior experiences with somebody who was exhibiting similar strength and manifestations that Mr. Ellis was?
Right. Now I recall it, yes.
Right. He describes being involved in a 6-minute altercation with somebody who was on PCP where physical strikes had no effect, right?
Correct.
And they struggled so long that they were going to reach exhaustion, and if he didn't render or attempt to render that person unconscious, he would have to resort to deadly force, right?
Absolutely.
And so in this case, his explanation for attempting an LVNR was based on his prior experience and correlating that to Mr. Ellis, right?
That's what he gives as an example, yes.
Right, and so he's explaining why I attempted the LVNR, because if he doesn't render him unconscious to restrain him, he may have to resort to deadly force, right?
I don't think he says quite that, but he does say in this prior event he thought he might have to go to deadly force.
All right, and that's if he can't restrain somebody in that circumstance, it can escalate to an altercation that requires a higher use of force.
Depending on if you have enforcement authority to begin with, depending on all these factors that we've talked about for 2 days.
All right.
And again, there's particular circumstances that the officer's facing at the time.
All right. In your report, you talk about that still photograph of Officer Collins' hand in the front neck area of Mr. Ellis. Do you understand?
Yes.
And you characterize that as Officer Collins choking Mr. Ellis. Is that right?
Well, I think I referenced that it's evidence of a chokehold, yes.
Okay. Well, you reviewed the autopsy report in this case, right?
Yes.
And there's no evidence of any sort of injury to Mr. Ellis's neck, right?
Correct.
And you described the chokehold being a hand over the throat, right?
Yes.
And that's what you think is depicted in the video, or at least shown in the still of the video.
Correct.
You realize that there's no bruising consistent with any force applied by any fingers on his neck, right?
Yeah, I don't think that it was very brief, second or two.
All right. Well, if I can get, with the court's permission, Exhibit 546 displayed. That's been admitted, Judge, and so with the court's permission, I ask them to publish that. But don't hit play yet, please. You're familiar with, well, nothing said word. 546 is the timeline synchronization, at least one of them, that Grant Fredericks prepared. You reviewed that, right?
Correct.
All right. And you listened to the volume associated with it?
Yes.
Okay. What I want to do, Mr. Ryan, is I want to have it played with the sound up until about 50 seconds in. Then I'm going to have them stop it, and I'm going to go back and ask you questions about what you see and what you hear, okay?
Sure.
All right. Can we hit play with the sound, please? And I don't hear the sound. Can we pause it, please? Can we get the volume? Who has access to the volume? Can we just ask the AG's office to pull up, apparently our version is not working.
If you would.
right, can you see that displayed?
I can.
And is that,
It's not very big, but I can see it.
can we start at the beginning, please? And are you able to use both of them to enlarge it? For the witness? You want it larger?
Yeah, it's a little hard to see on the small screen, yeah.
Mr. Ryan, you can step up to the court commission. You'll rip on the big screen too. Is that okay, Judge?
Sure.
Is that okay right there? That's okay. Thank you.
Yeah. Actually, it's getting bigger, so it's even
Well, there's going to be another image that's going to come right here, sir. So I wanted to give that. Can we start at the beginning, hit play with the volume, please?
Oh my God! Stop it! 7317, go ahead. Just arrest him! Oh my God, that was so scary! Hey, you're on the road right now! You got kids in the car, you dumbass, you already know. 7317. 37. Not 6 inches. Alright, traffic, Henry 317 on trouble 968, we're 2622. Try again. Go around them.
All right. Mr. Ryan, at the beginning of the video, for about 17 seconds, you can hear struggling between Mr. Ellis and the officers. Can you not?
You can definitely hear something.
All right. And we just watched, this is Mr. Cowden's video, you would agree?
Yes.
In the right portion of the screen as we're looking at?
Correct.
And yesterday you went through individual slides that documented what we just observed in real time.
Yes.
All right, and to the left, you can see the Taser applications that have been synced by Mr. Fredericks, right?
Correct.
And what we saw is after the first Taser application, Mr. Ellis go limp and Officer Collins attempt to gain his left arm. Do you remember seeing that?
Yes, and it's after the carotid restraint as well.
Yeah, we'll talk about that in a second. And then that Taser application wears off. You see that in the video as well, right?
The first one or the second?
First one, sir.
Yes.
And immediately after it wears off, you can hear Mr. Ellis say, try it again, right?
There's words. Can you play it again?
Well, we will in just a second. Did you hear that?
I
Or
heard
not?
words, but
Okay.
I wasn't sure.
All right. And then what we see is Officer Burbank, who's mounted between his legs, holding his right arm, be removed and tossed into the street, right?
I don't see that.
All right, let's rewind it to the beginning of Mr. Cowden's video and hit play through 40, whatever the seconds it was. Right there's fine. Thank you.
Oh my God, stop it! 7317, go ahead. Arrest him! Just arrest him! Oh my God, that was so scary! Hey, you're on the road right now! You got kids in the car, you dumbass, you already know. 7317. 37. Not 6 inches. Alright, traffic, Henry 317 on trouble 968, we're 2622. Try again. Go around them.
Please. Did you hear Mr. Ellis say, try it again?
Again, I'm having trouble hearing those words. There was definitely something that said.
All right, have you reviewed Mr. Hallimore's transcripts that he created based on that interaction?
I'm sure I did.
And he says that Mr. Ellis says, try again, right?
I think so.
All right, and that's immediately preceding the action of Mr. Ellis with his right arm removing Officer Burbank from his buttocks area, right?
I don't see that. I see him slide off, but I don't see him
You see the
actually
officer
physically removing him.
You see the officer just slide off of Mr.
Yeah,
Ellis?
I can't tell what caused him to slide off that way.
Okay, fair enough. All right, thank you. If I can have you pull up Exhibit 21 with the sound, please. probably going to have you come back up.
Okay, sure.
Thank you. And what I'll ask them to do is just hit play, and then once Ms. McDowell's vehicle passes, I'll ask you some questions, okay? So I want you to listen to what's being said and the actions of the officers and Mr. Ellis. Go ahead, please.
Behind your back. You're gonna get it again. Put your hands behind your back. Hands behind your back. Put your hands behind.
All right. So that's the perspective that I was talking about earlier, where my client, Mr. Collins, Officer Collins describes Officer Collins describes being behind Mr. Ellis, right?
Yes.
And they're attempting to apply the handcuffs after the first taser application. You see that there?
I hear them saying, put your hands behind your back.
Or you'll get it
Or
again.
you get it again.
And you can see the red light on the.
Oh, you see the taser, yeah, that's the laser on the taser.
Okay. And what we can see in the imaging is that Officer Collins and Officer Burbank are attempting to gain access to Mr. Ellis's hands, right?
Well, again, it's hard to see exactly that.
Well, I'm going to play it again, but what I want you to look at is you can see Mr. Ellis's hand on the cement, and you can see Officer Burbank's hand directly on top of it as they're saying, put your hand behind your back 4 separate times, right?
Let me see it.
All right, can we hit play it again, please?
Behind your back. You're gonna get it again. Put your hands behind your back. Hands behind your back. Put your hands behind.
Can you see Mr. Ellis's
His hand's down there, there's no question.
And you can see Officer Collins' left knee is on the pavement, right?
Sorry, that's why it's so much easier to look at it in the PDF version,
Okay.
because then you can see all those things.
Okay. I'm going to have him play it again so you can see Officer Collins has his left knee on the pavement. Mr. Ellis's head is to the left of the video, and both officers are trying to gain access to his hands. Just focus on that. One more time, please. Last time, I promise.
Behind your back. You're gonna get it again. Put your hands behind your back. Hands behind your back. Put your hands behind.
All right. Did you see Mr. Ellis moving his head?
That's a different question. I was focusing on the knees
Okay.
and all of that.
Let's do the knees then. Officer Collins' knees on the cement, right?
One is on the cement.
And the other one is up in the air, right?
Correct.
And Officer Burbank is on the other side trying to gain access to Mr. Ellis's hands, right?
Correct.
And Mr. Ellis's hands are on the cement, resisting being put behind his back, right?
Well, you can't see the resistance. You can't see that. It could be that the pressure on the back is holding him down too, which would prevent him from putting his hands out.
Okay,
I mean,
fair.
there's another point where he actually looks like he is trying to put his hands out.
Okay, all right, go ahead and have a seat. We're almost done. What's clear in the audio associated with Exhibit 21 is that Officer Collins says 4 times, very clearly and calmly, put your hands behind your back.
Absolutely, we hear that.
And that's what he should do in that situation, right?
Correct, but if you've got pressure on the person and they can't get their hands out from under them, then you've got to release them a little bit so you can get those hands.
Okay, but you can't tell that from that angle.
You can't tell if there's any resistance that he's providing to keep his hands underneath him.
Okay, all right, thank you. Almost done. Did you make any opinion about Officer Ford's use of force in this case?
So I didn't hear it. Officer what? Ford. Overruled. You may answer.
I did not.
Well, you know that Officer Ford was involved in the restraint just as much as Officer Rankin, right?
I'll sustain that objection. You can ask him what he knows about him.
Fair enough. You know that Officer Ford was the partner of Officer Rankin, right?
Correct.
That he responded to the scene at the same time.
Absolutely.
That he assisted in restraining Mr. Ellis.
He was I think, only at the legs.
Okay.
He was not putting pressure on his back at any point.
Okay. Well, he was at the same location as Officer Collins when he arrived, right?
Say that again?
He was at the same location as Officer Collins when he arrived, right?
I'm not sure which.
Relative to Mr. Ellis's body. That was a bad question.
At that point in time?
Yes.
Yeah, I mean, he wasn't there when all this initially developed, all the initial use of force that we've talked about.
Bad question. When Officer Ford arrives, he helped restrain Mr. Ellis's legs, right?
That's correct.
In the same manner that Officer Collins was attempting to restrain Mr. Ellis's legs at that point in time.
I think he was also trying to hold him up in the same way in maximal restraint.
Okay. As Mr. Collins was, as Officer Collins was.
Correct.
So why were you not asked to evaluate his use of force?
If he knows.
Yeah, I mean, I don't know the answer to that. I mean, it wasn't an issue in this case, as far as I know.
Well, were you only asked to evaluate certain officers' use of force?
I mean, I was asked to evaluate the actions of the officers involved in this case.
That would include Mr. Ford, right?
No,
He wasn't involved in this case?
he's not involved in this case,
Officer Ford's not involved in this case?
only as a witness.
Oh, so make sure I understand your response. You were only asked to evaluate the use of force of the three charged officers
The actions of the officers in this case.
that were charged,
Correct.
as opposed to anybody else that might have used force to restrain Mr. Ellis at the same time.
If I had seen anyone else using improper force, I certainly would have pointed that out. As I've said a couple of times, that other people had a duty to intervene.
Including Sergeant Lynn.
If Sergeant Lim was aware, then yes.
If he was aware of what?
If he was aware that there was pressure on his back through the whole event, I read his statement. Sergeant Lim seems to indicate that.
Overruled, you may answer.
Yeah, Sergeant Lim seemed to indicate that the only time, he was only there for a short time at Mr. Ellis, and the short time he was there, Ellis was on his side. Again, based on Officer Rankin's statement, that could have been when the search was taking place.
Were you aware that Sergeant Lynn helped restrain his legs as well? He being Mr. Ellis.
Sergeant Lim did hold the leg while they got the hobble on.
Okay. Which you're now saying is violation of policy, right?
To leave him in a 4-point restraint like that, absolutely shouldn't be done.
That was
Very
my question.
dangerous.
I asked you earlier if Officer Collins' attempt to restrain the legs of Mr. Ellis by crossing them over while handcuffed was inappropriate. You said it was.
While he's on his stomach, yes, you've got to get him on his side.
Okay. And so if Sergeant Lim did the same thing while Mr. Ellis is on his stomach, that'd be a violation of policy in your mind.
While leaving him on his stomach, yes.
Okay. And how about Officer Ford? If he did the same thing, that'd be a violation, right?
While he's left on his stomach, then yes. You don't leave him on his stomach. You don't leave him on his stomach even when you're not doing maximal restraint on the legs.
Well, didn't Officer Ford say that he did exactly that in this case?
For a limited purpose, to get the hobble on, yes.
All right.
We're now after 12.
I don't have any further questions for the witness, so that's a good time to judge.
Okay, so we'll break. Ladies and gentlemen, it's our noon recess. Please be back by 1:15. Please.